Welcome, everyone. Thank you so much for being here today for this panel on remembering Justice Ginsburg. Dean and Naya, did you want to say a few words to start?
I have to unmute. So I just want to say hello to everybody. And also, as we begin, I want to acknowledge that our law school and campus are located within the traditional territory of the Arapaho, Cheyenne, and Ute people. And I just welcome everybody to this panel discussion reflecting on the life and legacy of Justice Ruth Bader Ginsburg, a legendary and inspiring person, lawyer, and of course, United States Supreme Court Justice. We mourn her loss, but also celebrate her life. I had the privilege of arguing before her at the Supreme Court. I very clearly remember that when she joined in the rapid fire questioning, she had a calming demeanor and ever so slight smile that at that moment was soothing, even though her question stumped me. We have a terrific panel that will be able to talk about more robust personal encounters with the late Justice, as well as give insights into her monumental contributions to the cause of justice and equality. And with us to introduce and moderate our panel, you've already seen her and heard from her, is my outstanding colleague, Jennifer Sullivan, the law school senior assistant dean for administration. Jen.
Thank you so much. Thank you all for being here. I know that we've all learned things about Justice Ginsburg this week as the tributes have poured in. For me, one of the quotes that really stood out to me, or the anecdotes about Justice Ginsburg that really stood out to me, was the fact that at one point when her son's school was calling her incessantly about behavior problems, she said, you know, this child has two parents, please alternate calls, it's his father's turn. And I thought that would be remarkable almost to do today, sadly. So that really stuck with me. But it bears noting that before she ascended to the Supreme Court, one of the many things that Justice Ginsburg accomplished was to be the first woman to be granted tenure at Columbia Law School. And we thought it would be great to bring together a number of our current and former faculty and to hear their reflections about this line of the law. I'm going to be the moderator in name only today because I think once I run through these introductions, you won't hear from me because we have so much to hear from these incredible panelists. So I will briefly introduce them. We are going to have, first of all, Justice Melissa Hart with us, who is a Colorado Supreme Court Justice and a former full-time member of our faculty. Among her many accomplishments is the fact that she clerked for Justice John Paul Stevens of the Supreme Court, and so spent time working in close proximity to Justice Ginsburg. And we are so lucky to hear her unique perspective, which is now informed by nearly 3 years on the bench. We also have Professor Fred Bloom, who is a professor of law and associate dean for faculty affairs and research. He is a renowned scholar who is an expert in, among other things, modern federal courts. He's won too many teaching awards to count, and he'll be kicking us off today with a story about the late Justice. We have Professor Aya Gruber, who is an expert on criminal law and procedure, critical theory, feminism, and comparative law. Professor Gruber recently published a book called The Feminist War on Crime, The Unexpected Role of Women's Liberation in Mass Incarceration, which has been described as an exciting and brave book that tackles the cause and effect between gender-based violence, mass incarceration, and a broken legal system. We have Craig Konnoth, who joined our faculty in 2017. Professor Konnoth writes in health and civil rights and health data regulation. He's also active in LGBTQ rights litigation. Recently, Professor Konnoth was the lead author of an amicus brief submitted to the U.S. Court of Appeals for the 10th Circuit, which was signed by 50 law school professors, in support of the defendants in the 303 Creative LLC case, a case involving a web designer who refuses to design websites for same-sex weddings and wants to post that refusal on her studio's website. We have Professor Helen Norton, who is a longtime member of our faculty, an expert in constitutional law and civil rights law. Like Justice Ginsburg, she's also an experienced civil rights litigator. She's a former Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice. I hope she won't hold it against me when I say that if our faculty has someone who approaches the level of universal respect amongst her colleagues that RBG commanded at the court, it is Professor Norton. And finally, for our last 15 minutes, we'll be hearing from Colorado's Attorney General and our former law school dean and colleague, Phil Weiser, whom, as many of you know, did clerk himself for the late Justice Ginsburg. He'll be joining us for the last 15 minutes, so please stay with us for that. And so with that, Fred Bloom, Professor Bloom, I'd like to turn it over to you.
Thank you, Jen, for including me in this fun and important event. And thank you all for joining us today. I know none of you are here to listen to me. You're here to listen to my colleagues and my betters, and I will happily cede the floor to them very soon, I promise. But at Jen's invitation, I'd like to share with you a very quick story about a meaningful interaction that I had with Justice Ginsburg in the days that time has now forgotten. About 20 years ago, give or take a few, I interviewed for a clerkship in Justice Ginsburg's chambers. Now, I remember the day that I got the call almost perfectly, though I don't remember much of it. I don't remember the weather or the hour or even the day of the week. I just remember feeling deep in my core and with an intensity that still stings to this day that her secretary had called the wrong number. I still feel that way even now, but still, I'd been invited to interview with Justice Ginsburg, accidentally or not, and I wasn't about to miss it. So I prepared. I mean, I really prepared. I read every word that she'd written, or at least every word that I could find. I poured over my own writing samples and my silly student note. I talked to former clerks. I did moot interviews. I even tried unsuccessfully to eat and sleep. And then I flew to Washington, D.C. Now, my interview started well, and maybe it finished well too. I still don't really know. Her staff was gracious. Her chambers were warm, if also intimidating. Her clerks were incredibly impressive. As for Justice Ginsburg, well, she was both smaller than I expected and a lot bigger too. She was, as many of you know, a tiny person, 5'1" on a tall day. And the towering oak and marble of the Supreme Court building seemed to make all of us seem smaller, not just her. But she also seemed to me, at least on that day, so much bigger. Her quiet intensity, her immense wisdom, her subtle humor, as Dean Anaya suggested, and her undeniable steel more than filling any room that she ever entered. It was terrific to speak with her. I felt like I could have talked to her for hours. And the good news is that after all my preparation, she didn't ask a single question about many of the holes that I knew were in my student note. The bad news is that she did ask a lot of questions about the many holes that I didn't even know were there, but she found them for me. There was a lot of squirming. And then right near the end of the interview, a visitor came in, Justice Antonin Scalia. Yep, that's right. Right then, in the middle of my surely profound and original answer about the importance of judicial review or whatever, in he walked. Now, he and Justice Ginsburg were close friends, as many of you know, famous for attending opera and riding elephants together. And as I sat there that day, I thought for just a second that maybe they'd added a new hobby to their repertoire, pranking nervous clerkship applicants. How fun for them. Anyway, it soon became clear that Justice Scalia didn't expect to see me, and so he asked me, and this is a direct quote, "What are you doing here?" And I responded, and this is also a direct quote that my law school friends will never forget reminding me of. I said, "I'm not entirely sure, Your Honor." Might be the most honest answer any lawyer has ever given in that building. Not sure it helped my case. It is strange sometimes what happens when life throws you a curve. Now, for all sorts of reasons, both today and in the days and weeks and years ahead, we're going to focus on the wisdom and the good judgment that Justice Ginsburg showed in what she did, how she litigated her cases, how she fought for equality, how she wrote her opinions, how she battled until the end. But I think there's also wisdom and good judgment in what she didn't do too, how she didn't give up, how she never gave in, how she didn't flinch or quit or back down, even when the law and the profession and the world seemed aligned against her. And of course, there's one more thing that she didn't do that reveals her good judgment too. She didn't hire me as a clerk. Guess she wasn't entirely sure what I was doing in her chambers either. Now, my friends and colleagues will now jump in to talk about Justice Ginsburg's legacy, and I'm glad they've been given that question because it's not one that I think I could answer. But I would say this, I don't think all of her legacy is on the page. Even if we never read her opinions or her speeches again, we will forever think very differently about what it means to be a person of impact and purpose in this legal profession of ours. And that's because of her. That sure seems like something to me. Thanks for listening to my silly story, all. Please take over my betters. Thank you, Jen and Jim.
Brad, thank you so much for sharing that. As many of you know or would suspect, it is a small to vanishing percentage of even the top students at the top law schools who get an in-person interview at the Supreme Court. And that's just a wonderful story that I know will stay with all of us. Thank you. So I know that Justice Hart is here, and Justice Hart, I would ask you to lead us off with the panelists' reflections on Justice Ginsburg's legacy.
Thank you so much, Jen. It's nice to see all of you. Just because Fred started us off with an interview story, I'm going to share an interview story. It was not me interviewing, though. It was Justice Ginsburg. When I worked for, during this, one summer of during law school, I worked for a law firm called Jones Day, and particularly worked with Don Verrilli, who went on to become the Solicitor General and just an all-around brilliant lawyer. And he was tasked with prepping Justice Ginsburg for her Senate confirmation hearings. And he walked into the room with her and he said, "It's nice to meet you, Justice Ginsburg." And she said, "We've met before. You interviewed with me for a clerkship and I offered you with a clerkship, but you took a job with someone else." And it was the most startling direct statement. And it's one of the things that I remember talking to Justice Stevens about it, and I can sort of feel it now. Obviously, my court is different than that court, but that judges so rarely get people saying no to them, that the no's stand out in their minds in sort of remarkable ways. But that was also sort of something that was wonderful about her, is she just had this directness, sometimes awkward, but still always honest directness that was remarkable. I just walked back here to, I'm at my office. I know that's shocking, but I have a mask. This is my mask. I'm at my office with my mask. I just walked back here from History, Colorado, where they're doing a memorial for Justice Ginsburg as well. And Phil Weiser was also speaking there. And one of the things I started out by saying, I will also say here, which is it's not getting easier to talk about the loss of Justice Ginsburg. I feel that it's getting harder. And so if I cry, I apologize in advance. But one of the things that has struck me most as I've been thinking about her life and our loss and sort of everything that she stood for is we talk a lot about what a remarkable feminist she was and what a difference she made to the lives of women in this country. And that is absolutely true. Certainly, I feel the difference that she made in my life. But she made a difference in the lives of every man in this country too. Every single one of us, whether male or female, is better off because of Ruth Bader Ginsburg's time on this earth. And that's one of the things that, as I look at, I have a 15-year-old son and a 17-year-old daughter, and I look at them and realize that because of her, because of what she did, because of what she imagined as possible in terms of a world that treated men and women more equally and gave men and women more opportunities, both of my kids will be able to be better parents than they could have been before she changed the way we viewed gender equality. And both of them will be able to be better workers, and better workers, that sounds horrible, to have better opportunities outside of the house because of her. And there are not a lot of people in the world about whom you can say they changed everything for all of us, but she really is one. And I sort of think I might just stop there. I don't know if there's going to be Q&A, but I actually would love to hear from my former colleagues who I think will have wiser things to say. But that's just my current reflection. And now I'm not going to cry. I'm going to stop. Go.
Thank you so much, Justice Hart. It's really special to hear you speak about her, especially because you are now a justice on our Supreme Court. Thank you so much for sharing that. We will have some, I'm hoping we'll have some time for Q&A as well. So if you're in the audience and you're thinking of questions, you can start to share those in the chat, and hopefully we'll have time to get to them. But now I'm going to ask Professor Aya Gruber if she would speak.
I'm so thankful to be on this esteemed panel, and I feel like I don't know what I'm doing here. I have a little bit of an imposter syndrome. And now that I've found out that Justice Ginsburg had the chance to and declined to hire Fred Bloom, I'm not sure I can participate in this Festschrift anymore. No, but seriously, I was surprised because I didn't know or have the opportunity to be in the lofty halls of the Supreme Court. I did have dinner with Justice Ginsburg and Marty once, so that was very cool. And I do criminal law, and Justice Ginsburg was a reliably civil rights protecting voice in criminal procedure, but she wasn't, the probably most notable justice in that realm. But then I thought to myself, I am a woman in the legal field. I'm a law professor. I would not be here if not for Justice Ginsburg. So I have something to say, and I'm going to say it. So I think like most people outside of the legal world who probably aren't on this call, think of RBG in terms of iconography, right? The lacy collars, the ironic name that compares a diminutive woman to Biggie Smalls, the clip of her in her advanced years lifting the weights, and her dissents, right? Really starting with Bush v. Gore, where she consciously left out the respectfully from I dissent. And then Shelby County, where she famously said, quote, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. And of course, the dissent in Ledbetter. But really, she wasn't what we would consider to be a firebrand, right? She had far fewer memorable snarks, right? Maybe the umbrella one being one, than Scalia. And when I was at dinner with her, and my husband, Brett, if any of you know him, was seated between Marty and Ruth Bader Ginsburg, and he was like, what? And I'm like, no, this is really important. But anyway, when I was at dinner with her, I said, Justice Ginsburg, what do you think of all those snarky opinions that Justice Scalia writes? Do you think that they're, appropriate for, the lofty Supreme Court? And she was like, yeah, they're great. But she said, I couldn't do anything like that. I don't have the ability to do that, right? And so that said a lot to me about her, right? She wasn't snarky and in front like that, but the changes she made today seem so natural that we forget, right? That there was a time, and it wasn't too long ago, where women's primary role in life was to bear and raise children. And that it's not like that seems so natural that we forget that it was she who fought this relentless, incremental, single-minded fight to establish that principle, that women are not only deserving of equality, but that they shouldn't be judged and stereotyped on the basis of sex. So, just two more little tidbits that I'll throw in here that were meaningful to me. It's interesting to me that, first of all, her, one of the biggest parts of her fight as a lawyer against sex discrimination started here in Colorado. In fact, in Denver with a bachelor named Moritz. And it showed that she was strategic about her litigation, and it often involved men. And in this particular case, this bachelor was caring for his ailing mother, and he wanted to get a dependent tax deduction. And those of you who have seen her biopic will probably remember this case. And at the time, the tax code said, no, the only time that men can get these kind of dependence deductions are if they're widowers or their wife is debilitated. And, she chose this case as a centerpiece of her litigation strategy, knowing that it was on behalf of a man, but that the principle it enshrined was the idea that women were primary caretakers, right? And she won this in the 10th Circuit, and that case greatly influenced some litigation in front of the Supreme Court, a case called Craig v. Boren, which was also about men and their beer. It was a law that allowed women to drink beer at 18, but men to drink beer at 21. And it was a winning case in the Supreme Court, and actually the first case that established the intermediate scrutiny test. So in my work, and then I'll shut up because I'm not any kind of constitutional expert, I work on feminism and criminal law. And one of the things that RBG's litigation strategy really said to me was she recognized that laws and criminal laws made in the name of protecting women could also reinforce harmful stereotypes. And a lot of people don't know that she filed a signature brief in the 1977 case, Coker against Georgia. And that was a case which considered the constitutionality of the death penalty for rape of adult women. And in it, she wrote a brief in favor of the defendant, arguing that these harsh penalties were actually sexist. And here's what she said in her brief, and I'll leave you with this. She said, the death penalty as a potential sanction for rape is part of the fabric of laws and enforcement patterns based on an obsolete and demeaning notion of women, which inevitably yields lack of enforcement of rape laws rather than protection of women. Amici submit the instant brief on behalf of a large segment of the women's legal community who oppose the death penalty for rape as a vestige of an ancient patriarchal view of women as the property of men, as a reflection of societal ambivalence towards the women victim, and as a barrier to proper and vigorous enforcement of rape law. Review of the history and impact of the death penalty for rape demonstrates that it is premised on chivalric concepts of property and protection, which this court has noted puts women not on a pedestal, but in a cage. And I'll leave it with those words.
Thank you so much, Aya. I think it is patently clear to all of us, including people who've never met you or heard from you before, why you're on this panel. So thank you so much for those thoughts and observations. And now I would ask Professor Craig Konnoth to unmute himself.
Thank you, Jennifer. And again, in my case, it is truly a question as to what I'm doing here to echo, to accurately echo Fred. I'm by far the most junior person here, and I do not have, I'm sad to say, these wonderful memories that we've heard about and that I know we'll hear more of. I also just want to note, given the time, I just want to a little addendum to the Coker brief. Justice Ginsburg also notes in the brief how the narrative of applying the death penalty to rape was meant to further this narrative, of dangerous Black men and pure white women, and so she also notes heavily the racial dimensions of the rape laws in Georgia and elsewhere in the South at the time. So I suppose the most I can say about my relationship with Justice Ginsburg is how much of a proxy it was, right? I mean, I knew a lot of eminent. I was lucky to know a lot of eminent people who had met her or knew her, including, as I find out today, Fred and Aya. The reason I say that is because she was always in my thoughts, but not someone I had met. Before I entered academia, I was California's Deputy Solicitor General. And in that job, I used to spend nearly all my time, about 90% of my time, working on briefs involving California before the US Supreme Court. Now, I admit, most of my time thinking about Justice Kennedy, sometimes about Justice Scalia at the time, very rarely about Justice Ginsburg, who, we we knew, California was usually on the progressive side of many cases, and we sort of knew the way she would go. But in many ways, she would always enter the conversation, especially in cases involving discrimination. And I'm going to come back to that. The second reason she was, a little bit, part of my life was opera. So some of you might know that I frequently haunt the Colorado Opera and other opera halls. And I actually saw Justice Ginsburg from afar at two opera festivals. One was the Glimmerglass Opera Festival, and the other one was the Santa Fe Opera, which of course is a very famous opera festival. And that time I was actually supposed to meet her. Two of my friends were getting married, both of them who worked at the opera, one who was singing that day. Some of you know how I drive. And so I was supposed to arrive, I think at 3 p.m. I got there at 5 p.m. And the ceremony was long over, and there were actually concerns about whether I would actually make the opera itself. And by that time, of course, it was too late to meet Justice Ginsburg. And then the final thing is actually something I heard from a former law clerk of Justice Ginsburg, Anne O'Connell, which is that Justice Ginsburg was a night owl and would get most of her work done between 12 and 3 a.m. And the fact is that I also suffer from pretty awful insomnia most of the time. And so I also get most of my work done between 12 and 3 a.m. And so I remember thinking when I heard that story of all the hours that I would spend working at that time, and the idea that, Justice Ginsburg is also, working at that time, and sort of validated me, because, everyone I seem to know seems to wake up at 5 a.m. and start working. But Justice Ginsburg, I understand, would drive to the court and sneak in just before 10 a.m. oral arguments, which is, generally my MO as well. So so that sort of helped validate who I am. But so much for that. I think the most personal and important legacy of Justice Ginsburg for me was her work on sex discrimination. So most of you know I teach sexuality and law at the law school, and also I do a lot of litigation. So one of the cases I filed a brief in was the Bostock brief that recently held that Title VII covered sexual orientation and gender identity discrimination. Now, the first person to file a brief before the US Supreme Court saying that sex stereotyping was a problem, that actually created the categories for suspect scrutiny, the criteria for suspect scrutiny. And if I was if we were all here in person, I'd call on some of my former students to ask what those criteria are. So feel lucky that you are spared. But immutability, history of discrimination, those kinds of terms. So Justice Ginsburg was the one who filed a brief in Reed versus Reed saying, look, let us compare the criteria of African Americans and women, and those criteria should determine what constitutes suspect scrutiny. Those are the criteria that have then been used in LGBT litigation. Those were the criteria that were used to explain that stereotyping of the sexes was problematic. And those were the arguments that were ultimately leveraged in the Bostock case, for example, that said, look, just as it is a stereotype to expect a member of the military, a female member of the military, not to support her husband, Frontario versus Richardson, it is also a stereotype to expect a woman to only be married to a man. And it is that legacy, those arguments that actually brought the massive LGBT victories we've seen in the last few years. So I'll stop there, and hopefully we can get to questions. Thank you.
Thank you so much, Craig. It's your alacrity of mind that you could keep together opera, driving habits, owl tendencies, and the finer points of sex discrimination law so quickly. Thank you very much. Professor Helen Norton, I would ask you to share your perspective on Justice Ginsburg's legacy at this time.
Thanks, Jen, and thanks everybody for sharing your time with us today. Justice Ginsburg was one of a very few Supreme Court justices whose work before becoming justice was at least as important as their work afterwards. The same was true of Thurgood Marshall, to be sure, and maybe a few others, but not many others. And as was also the case of Thurgood Marshall, Justice Ginsburg's work, both as a lawyer and later as a justice, was directed to the struggle for equality, meaningful equality, functional equality. And with respect to that struggle for equality, both as a lawyer and as a judge, she was in it to win it. And she recognized that winning, especially winning something as important as equality, is a long game that requires patience, that requires resilience, that requires creativity and strategy. And so especially for the law students in the audience, I want to give just a couple of examples of her patience, her resilience, her creativity, her strategy in this long game for equality. Now, as a lawyer, before she became a justice, she sought, among other things, to broaden courts' understanding of the constitutional term equal protection, to broaden their understanding of that term to include a constitutional commitment to gender equality, even though the Equal Protection Clause says nothing specifically about sex or gender. And when she was litigating this issue in the early 1970s, her audience was a federal judiciary that was almost exclusively male, including a Supreme Court that was entirely male. And for this reason, and both Melissa and Aya touched upon this as well, for this reason, she was strategic in her case selection, emphasizing cases in which men as well as women experienced tangible harm from sex discrimination. And I'm thinking, for example, of Frontiero versus Richardson, where she challenged the military's policy of automatically providing male service members with spousal benefits, regardless of any financial need, while only providing a female service member with spousal benefits if she could prove her spouse was financially dependent on her. And I'm also thinking of Weinberger versus Wiesenfeld. Again, I alluded to this, where she challenged the Social Security's program that provided widows, but not widowers, who were raising minor children on their own, with survivors' benefits based on their spouse's earnings. Now, both of those discriminatory programs hurt working women by providing them with less compensation, with a smaller benefits package. Both of those discriminatory programs also hurt men, especially men in caregiving roles, by failing to provide them the same support as their female counterparts received. And in both of those cases, she persuaded the Supreme Court that the government's discrimination denied equal protection in violation of the Constitution. So an example or two from her service as justice, where as a strategic matter, she viewed every opinion she wrote, regardless of whether it was a majority opinion, a concurring opinion, or a dissenting opinion, as an opportunity to move forward in equality's long game, even if it looked like she was losing in the short term. Now, sometimes her audience was jurors or trial judges deciding summary judgment motions in the future, where she was trying to make important but complicated legal standards understandable to those legal decision makers. And I'm thinking, for example, of her concurring opinion in a case called Harris versus Forklift Systems, which was a statutory case involving Title VII's protections against workplace harassment that wrestled with whether and when verbal harassment in the workplace is sufficiently severe or pervasive to alter the terms and conditions of employment and violate Title VII. And she took that complicated, kind of bland legal standard and tried to give it life, to try to make it easier for legal decision makers to apply. And she said, the question we're really interested in is whether or not this harassment makes it harder for a woman or a person of color or a woman of color to do their job. In other words, do they have to run a gauntlet of sexual or racial epithets or abuse that their white male counterparts don't? And if they do, they have a different and worse job as the result of discrimination. Her dissenting opinions, I mentioned this as well, were also designed for equality's long game. And I want to talk about the Goodyear Tire and Rubber versus Ledbetter case that I mentioned. That's a statutory interpretation case involving Title VII. Now, in a constitutional case, of course, if you're unhappy with the Supreme Court's decision, you either have to convince the court, this court or a future court, to change its mind, or you have to amend the Constitution. That's not easy to do. In a statutory interpretation case, at least, if you're unhappy with the Supreme Court's interpretation of the statute, you can go to Congress and ask them to amend the statute to correct the court's interpretation. So in this case, Lily Ledbetter, the plaintiff, had been paid less, demonstrably paid less than her male counterparts for years, even though she was doing the same job. But she didn't learn of this until decades later. And when she found out about it, she immediately filed suit. But the Supreme Court's majority overturned the jury verdict that she had won, and it interpreted Title VII to conclude that her suit was time barred. She had blown the statute of limitations. What she should have done was file suit at the time the first discriminatory decision was made, even though she didn't know at the time that it was discriminatory. So Justice Ginsburg's dissent explained how the majority ignored how pay discrimination really works, how it's often incremental, how it builds over time, and it's often concealed from the victim. And she closed by noting expressly in her last sentence that Congress had the power to correct the majority's mistake by amending Title VII. And Congress quickly did just that. And the Lilly Ledbetter Fair Pay Act was the very first bill signed into law by newly elected President Barack Obama. So those are just a few examples of Justice Ginsburg's, what I think of her as clear-eyed search for ways to move forward in the fight for equality, even in the midst of what feels like a setback. And I think that we can learn a lot from that sort of resilience in the face of adversity. And I think that's true now more than ever.
Thank you so much, Helen. That was not only informative, but also inspiring and hopeful, which I think many of us are looking for reasons for hope now more than ever. At this point, we have a few minutes before Attorney General Weiser is going to join us. So we have some time for questions. And so I'd ask if you have a question, please go ahead and put it into the chat. I hope I'm coming across. I hear my audio may not be great. And so I'm looking for questions. And I guess, and I'd also encourage the panelists, if you have reactions to any of the thoughts that your fellow panelists shared, feel free to make those. I guess I'd start off questions to follow up on a point that you just made, Helen, which is that it seems as though there were several times where Justice Ginsburg's opinions or the cases that she took and argued were informed by her experience as a woman. I remember another case involving a school search policy that involved a 13-year-old girl and her own perspective on that. So, you know, I think a lot of people are wondering about what may come. We have a new nominee. Is there a concern that the loss of that particular perspective will have, you know, consequences for women in particular? And I guess I'd ask that question.
I'll start, but I'd be very interested to hear what the other panelists have to say. One of Justice Ginsburg's strengths was that she was willing and able to speak from experience. This is how discrimination works on the ground. Not many justices have been able to do that. Thurgood Marshall, of course, I think today, Justice Sotomayor often does this, especially powerfully. Justice Sotomayor is still on the court, of course, but in losing Justice Ginsburg, we lose a consistent voice for the lived experience of inequality. And I'm not sure there's a replacement on the horizon.
One of the interesting things that you know, I'm going to say this from that we talk about here on my court is how the addition of a new member changes the dynamics, that we all change a little bit when there's someone new here, because when you've got a group of a collaborative decision-making body, inevitably the different voices that come and go change what the others are responding to and kind of what the others feel it's worth fighting about. And I mean fighting in a nice way, arguing about. And I wonder, and I just think we truly don't know. There's so much focus in the media on the dynamics of the individual person who's been selected to replace Justice Ginsburg. But I think it will be very interesting to see how the other justices on the court change. And for example, whether Justice Kagan finds a stronger voice as a woman, which has not been, I mean, she has been a woman this whole time, but that has not been sort of a way that people have thought of her as a strong voice for women, but whether that will be something that happens, I just think we can't know, but it strikes me that that's possible, that her voice will change in these new times.
If I could chime in, Jen, take Dean's privilege, I guess. Following up a little bit on what Justice Hart just said, there's a lot of talk about judicial philosophy, and her friend, Justice Scalia, was fancied himself an originalist, a particular type of one. And now we hear a lot about textualists, Justice Gorsuch, of course, being at the forefront of that way of, or that judicial interpretive model. And even Justice Kagan, she explained to us when she was here, she sees herself as a textualist. Perhaps one of the panelists could comment on Justice Ginsburg's judicial philosophy and interpretive model, and the extent to which we might not see that philosophy or model or method much present anymore in the court or in the future, given the changes and the changes to come. How about you, Helen?
That I have, if there are no responses to that, I have two questions that some audience members have posed, maybe somewhat controversial, but I think fair question. And we all saw pictures of Justice Ginsburg's former clerks standing out in front of the Supreme Court in what was really a beautiful tribute to her. But there was a question about thoughts on her practice of hiring law clerks and how it relates to race and the makeup of her law clerks in the past. So I see Aya raised her hand.
Yeah, because I had forgotten in my remarks to address that. There is a sense in which people have recently criticized Justice Ginsburg for not practicing what she preached, right? In the sense that she had been on the bench for 38 years, in total, and had hired one Black law clerk. And I think, Craig can say more about that because I think he knows this law clerk. But I did want to add that, there is a really interesting moment in which she did something that I think is too rare in sort of legal argumentation, legal academia, and that is giving credit to people who are lesser known forebears of arguments. And in that case, Reed v. Reed, that I think Craig mentioned, she put as a co-author on the brief Polly Murray, who was a civil rights icon, who Thurgood Marshall said wrote the book on how to litigate equal protection cases. She was the coiner, Polly Murray, of the term Jane Crow. She was the valedictorian of her law class at Harvard, and she was a queer Black woman. And so, this kind of gets lost in the festivaling of, the most visible icons who, just based on the way the world is, have tended to be, male, and now we have more female, and RBG is a female icon, but they also tend to be white. And that she gave due to somebody who really should be more of an icon in this world, and that's Polly Murray. So I'll just leave it at that because I had wanted to mention Polly Murray.
Yeah, absolutely. And I and I were chatting about how, oh my gosh, we both meant to mention Polly Murray, and we didn't have the time to. But I think it's important to recognize, right? All of our heroes, we can respect them, we can look up to them, but we should never lionize or idolize them. In fact, I think that Justice Ginsburg herself would admit to having things that we could learn from her in some ways. And I think that is one thing. So Paul Watford was the Black clerk she hired. He's now a judge on the Ninth Circuit Court of Appeals. I do know him. He probably doesn't remember meeting me. I just met him when I was clerking. But yeah, I mean, I think that, so Justice Ginsburg did work on issues of race, right? I mean, the Coker brief that Aya referred to, her reference to Polly Murray. But I think that what we can also learn is, to some degree, all our blind spots, even those of us who are engaged in equality work. I mean, I know I come at race with my blind spots, and I think we all can. And so I think that you know, that is an area where you know, even in learning from an idol like her, we should learn that we too have our blind spots that we should focus on in this particular area. So I'll stop there. Thank you.
Thank you. I expect that Attorney General Weiser may be here already. Is he? I'm trying to see. While we wait, if it's okay, Sasha Strong put a chat or put a comment in the chat, and I wanted to read it to make sure that people see it. And she wrote, "As a woman, I am forever grateful for the contributions of RBG. As an Indigenous person, it's hard to rectify her past decisions. That being said, however, her recent position on the McGirt v. Oklahoma decision showed her ability to evolve and recognize tribal sovereignty." Just thought that's a great comment and really squares nicely with what you just said, Craig. So with that, I wanted to see if General Weiser is here. So, okay, let me see. I don't think he's here yet. Justice Hart, did you just say something?
Yes, I said Phil is here.
Yeah, he's here.
Great. Okay. Well, Phil, thank you so much for joining us. We heard from Justice Hart that you were just speaking at another event memorializing Justice Ginsburg, and I know that you've been speaking widely about this ever since September 18th. So thank you so much for joining us. We're really so honored to have you here as well. And with that, I'd ask you if you would share your thoughts and reflections on her legacy.
Well, I want to thank you, Jennifer. Thank you, Dina and Aya. It's important that we celebrate and remember Justice Ruth Bader Ginsburg, and how her story, as Chief Justice Roberts put it, is really a demonstration of the American dream. The American dream that the child of immigrants, a Jewish woman at a time when there were quotas for both women and Jews going to law school. There were law firms that wouldn't hire someone for being Jewish woman. And in her case with a child, she said that she had 3 strikes against her. But one of the things that her story tells us is we can't get down. We can't allow ourselves to be cowed or cynical. We've got to stay positive and focused. And she did. She found a path. That's why the word trailblazer is not underused. She literally found her own path. She helped build up the ACLU Women's Rights Project, and obviously then was appointed to the DC Circuit, where she had extraordinary legacy, and then at the Supreme Court. And my year was a very special year. I had special co-clerks, one of whom, Paul Watford, was actually on the short list under President Obama for the Supreme Court. African-American judge who honestly, I think could be a Supreme Court justice someday. The year I clerked, he was the best lawyer in the building, and I learned a lot from Paul. I learned a lot from Justice Ginsburg about being a great lawyer, and that's something that, again, for the law students out there, I will tell you, RBG pushed me like no one ever had. She had a demanding view of what legal writing should look like, and every word and every opinion she used was mindful, and all of us benefited from that. She also clearly had lived a life where her imagination about what the world could look like drove her and made our nation a better nation. Linda Greenhouse's piece in Sunday's New York Times, I thought, was outstanding on that regard. And what I also want to emphasize is she did it with support from Marty. And if you saw that movie On the Basis of Sex and know about the Moritz case here, they were a team. And at the 10th Circuit Judicial Conference years ago, there was a great speech that initially was given by Marty, but he passed away. And she gave it about how together they worked on these matters. Dahlia Lithwick wrote it up in the Slate publication. It's a special read. We're going to miss her. She left an extraordinary hole in the hearts of those who knew, and We're fortunate enough to have her as a friend and mentor, and she leaves a hole in our nation on the Supreme Court. But what I would leave with is all of us can and should take from her legacy, her lived experience, lessons about the work that we have to do. And here in Colorado and the Colorado Law faculty, you've got so many examples, those on this Zoom call, of leaders who are fighting for equality and justice, whether it's indigenous peoples, whether it's in the healthcare system, the criminal justice system. We've got a lot of work to do. And together we can continue doing that work. I know there's reasons that people are scared. We're living in a scary time. But my message is we have to take the inspiration from Justice Ginsburg to persist and to do our work together. Like it says in Ethics of Our Fathers, if it's not your job to repair the world by yourself, but no one's free to desist from doing their part. So please find your part. All of us have a part to play. And I thanks for your engagement and would love to join with others for questions. So Jennifer, I'll turn it back to you.
Thank you so much. Thank you so much, Phil, for being here and for sharing that. So we are opening it up to questions. Feel free to chat them to everyone and I will read them. Waiting for those to come in, I just had a question, I guess most closely for you, Phil, but you know, you read her opinions and they're so perfectly formed and it feels like they were just, they just came out that way. But I wonder if you might speak a little bit to the process of, you know, discerning, you know, what her opinion would ultimately be. Was it always as clear as it seems when you read the opinion, or did she really grapple with some issues and some decisions? And what did that look like? Am I frozen or is Phil frozen?
I think Phil is frozen.
Well, I would potentially, well, let's see if he comes back. I would ask other panelists. I know, you know, that you all have familiarity with judges and how they come to decisions, but I guess I would ask to other panelists for any observations on what that process can look like. Because I think for law students, when you read these opinions, you know, again, it often seems like it was a foregone conclusion, and of course it's not, and there's a process that goes into that. Any thoughts on that? Maybe you, Justice Hart.
Yes, I can tell you that it is rare, especially in a certiorari court like the Supreme Court or ours, that a decision is a foregone conclusion. They take cases because they're hard. I think we focus so much on the most political cases that the US Supreme Court takes, and some of those feel like very foregone conclusions, but even those ones I suspect are often not. But I think when you think about the vast majority of decisions they make, they're hard questions of interpretation, and even if they're hard questions, and I don't think they're foregone conclusions at all. And I do think it's an interesting thing about, I think about being a law student, and for all of the law students on here, it is true when you read them that these cases seem inevitable. Because in fact, an opinion is a piece of advocacy. We don't talk about it that way, but every opinion you write is a piece of advocacy. As a judge, you're trying to convince the world that in fact this opinion was inevitable. So that's what you're doing with your opinion. And if you do it well, you know, people don't stop and say, could this have come out a different way? I'm curious what other folks think.
I think that Phil, you may be back. I don't know if you heard the question, but we were talking about that process that that Justice Ginsburg would go through in coming to these opinions that seem so, you know, perfectly formed and foregone when you read them. Are you able to comment on that? Okay, we may still have some connection issues there.
I will note that I was watching an interview of Justice Ginsburg where she said that she sleeps between 2 but no more than 4 hours a night, and she would always take the hardest civil procedure cases. She was known as the civil procedure maven of the court, and that sort of gives you, I think, an image of how she would get into the meaty issues and difficult legal issues, on that front. Sorry, if Phil is back,
I'm back. Sorry about the technical difficulties. But what I was saying is she put that effort in that Craig was talking about, and she made it look easy. She did so much, but it reflected just her work ethic that was extraordinary. It also made being a clerk seem somewhat of a luxury in that almost none of what we did seemed as relevant as the fact that she knew where she wanted to go and every word she wanted to use.
That's great. Thanks so much. Any questions from the audience? I don't want to take up all the time. These are some amazing panelists. So if you have a question, now's your moment. I really like what you said, Phil, a moment ago about not being cowed and not getting cynical. I think that's a really important message for all of us right now, and appreciate you saying it. Also, I wanted to take this moment just to let everybody know that tomorrow evening we'll be having the first in our lecture series, Race and the Law at the University of Colorado Law School. Our own Dean Anaya will be presenting his lecture, Race and the Law, Equality Still Dampened. So please join us for that. I'm not seeing any other questions. I saw something
Craig's got a question.
Yeah, that's a question, but I just wanted to pick up on something that Phil said, which was, Justice Ginsburg's sort of last words, her fervent wish that no justice be seated until a new president be seated. And I think that those words, I say this, I'm not an elected official in any way, or a judge myself. So, but I do want to note the words of that, right? It wasn't after the election. She didn't say, I want a new my successor should come after the election. She said that my successor should come when the new president is seated. And I think that is as far as she could go in telling us to fight forward and forge ahead, and to go ahead and, vote with our consciences in this coming election. And I think that was her last clarion call, to us, to make sure that this country continues to survive along the lines that she had tried to establish.
I would add, I think the question was, it is my most fervent wish, which is very RBG, that she would have most before fervent. She did pick her words very carefully.
Thank you so much. So Professor White is on the chat as well. So I wanted to bring light to his comment, which is about the racial composition of her clerks. And he writes, one Black clerk in 37 years. In her 1993 confirmation hearings, RBG was challenged about her failure to hire Blacks, which already struck many as problematic. She said she'd do better. Better was one Black hire over the next 27 years. Any comment on that?
I didn't know the number, but I did know that Paul Watford, who I guess is that one Black clerk, was my co-clerk. Paul's extraordinary, truly, truly amazing. He's learned a lot from RBG. He started out as a great writer, by far and away the best writer in the building, and I said best lawyer in the building. We're lucky to have him on the Ninth Circuit Court of Appeals.
Well, I was just in a panel where I heard, Judge Watford speak, and he mentioned that he did not work on the VMI decision. But I was wondering, and obviously I'm not asking who did or whatever, but I was wondering if you have, there are only a couple of minutes left, but if you have any reflections on what some would say was one of the biggest cases that Justice Ginsburg wrote as a justice.
Well, if you watch the RBG documentary, there's a clerk who joined her at VMI, and so that gives you a little bit of a hint on that. Both Paul and I had let's call it front row seat on that decision. And I will tell you, she was so excited to work on it because she's writing this opinion, letting women into this all-male military academy, and it builds upon her prior cases, as well as Justice O'Connor's prior case involving a nursing school in, I believe it was Mississippi. And she plays up the language O'Connor introduced in that case called, you need an exceedingly persuasive justification to keep women or men out of an area that plausibly they could do the job. And that was her view as to military work. And when they invited her back along with the clerk who joined her, they said thank you for that opinion. And so she, I think, got a lot of joy from the ability to write that opinion. She put her heart and soul into it, and it made a big difference.
Thank you so much, everyone. We are right at time. I know some of our panelists have classes to teach and jobs to go on and do, but we thank you all so much for joining us today. Thank you to our esteemed panelists, especially Attorney General Weiser, Justice Hart, Professors Norton, Bloom, Gruber, and Konnoth. And we appreciate everyone who attended today. This session was recorded, and so we can make that recording available for people who may have missed it. Thank you.